My name is Tim McGovern. I'm a partner with Floyd Zadkovich in the Chicago office, and I'm going to talk with a little bit about setting aside an arbitrator's decision under U.S. law. Like most jurisdictions in the United States, arbitration is fundamentally a contract term that is agreed to by the parties. If there is any doubt about whether the parties agreed to arbitrate, the United States courts generally resolve the issue in favor of arbitration. Therefore, whatever dispute is before the court will then go to arbitration. At the conclusion, a party seeking to set aside the arbitrator's decision faces a very high threshold. Note that seeking to set aside an arbitration award is not an appeal of the decision in the United States. Some jurisdictions, for example England, will allow for the appeal of an arbitration award, but in the U.S., arbitrators' decisions generally cannot be appealed. In addition, U.S. courts generally do not like to impinge on the arbitrator's decision, especially because the parties have agreed to resolve the disputes via arbitration. U.S. law provides for some grounds for setting aside an arbitration provision, and those are located in the Federal Arbitration Act. The four grounds the Federal Arbitration Act identifies are 1. Evidence of corruption or fraud. 2. That the arbitrator was evidently partial to one side. 3. The arbitrator was guilty of misconduct or misbehavior material to the controversy. Or 4. The arbitrators exceeded their powers or failed to execute their responsibilities such that you cannot consider the award to be a final award or a complete resolution of the dispute. In addition to those four provisions found in the Federal Arbitration Act, United States courts have set aside arbitral awards when the arbitrator exhibited manifest disregard of the law. In order to prove that an arbitrator committed manifest disregard of the law, the error by the arbitrator must have been obvious and capable of being readily and instantly perceived by an average person that is qualified to serve as an arbitrator. The implication is that the arbitrator appreciated the existence of clearly governing legal principles, but just decided to ignore it. For example, manifest disregard of the law has been found where the arbitrator was presented with controlling law, but flat out refused to apply it. Now, interestingly, United States courts will not revisit the facts of a case. So if the court determines that the arbitrator believed that a certain law to be inapplicable, the court still may not set aside an award. The moving party has the burden to show that an average person who is qualified to serve as an arbitrator for that particular dispute would have readily and instantly perceived such a failure and considered the law that was applicable. Therefore, you can tell setting aside arbitral awards is very difficult in the United States. United States courts generally believe that if the parties agreed to arbitrate, then they also agreed to be bound by the results of the arbitration. Thank you, and I hope you found this informative.